Hello, good afternoon. Thank you so much for joining us for this conversation with the California Privacy Protection Agency. My name is Jeewon Kim Serrato. I'm a partner in the BakerHostetler and immediate past chair of the CLA, California Lawyers Association Privacy Law Section. We're joined by Ashkan Soltani, the executive director of the CPPA, and Brian Soublet, the acting general counsel of the CPPA. We're honored that you're able to join us for this webinar today. Thanks very much.
You're welcome.
As we know, the California Privacy Protection Agency voted on June 8th to move forward with the CPRA rulemaking. And today's webinar is going to explain to you from Brian and from Ashkan what the goals are from the draft regulations, how some of the rulemaking process works, what to expect in terms of rulemaking from here on out, and also some tips for how to engage with the agency, how to submit effective comments. And if you're not officially submitting comments, what you can do to continue to participate and to engage with the agency. So we have prepared a number of questions for you, and we're going to go through them. That's going to stay mostly on the procedural questions, and just wanting to let you know that we, because Brian and Ashkan is speaking on behalf of the agency, will not be engaging in direct substantive discussions, but there are a number of questions that I have posed to them. So hopefully they'll give us some insights onto what we expect to see in the rulemaking. So first, we're going to talk about the rulemaking timeline and process. And I think the first question that we get the most often is, did the 45-day comment period begin? Did the clock begin in terms of kicking off the rulemaking process? So Brian and Ashkan, please tell us, did the clock begin?
The clock has not begun, and I understand that there was some confusing. The release of the drafts that we saw prior to the June 8th board meeting were kind of a fluke of the Bagley-King Open Meeting Act requirements, and that any materials that are submitted to a majority of the board for consideration have to be made available to the public. And so in doing that, we provided the draft and the draft of the initial statement of reasons so that the board could take action to approve the executive director moving forward with the rulemaking package. So as of yet, the comment period has not started.
Brian, could you tell us a little bit more about the Open Meeting Act? I know that the agency talked about it at length, kind of the challenges, I would say, those are my words, of working with the Open Meeting Act and how the agency really must disclose, like you said, the draft regs even before you vote on it. Could you tell us a little bit what that means for those of us that are tuning in for the first time and might not have listened in on those agency meetings?
Yeah, I mean, Bagley-King is a law, and it's basically a transparency law. And any board or commission of a state entity, has to conduct their business open with public availability, even meaning that the public has to be allowed to be there where the board members are deliberating. So at any point in time where a majority of the board is meeting to deliberate on an issue, it has to be noticed, and there has to be an agenda. And the notice has to be, like 10 days in advance of the meeting. And so what we operate from is that anytime the board reaches a decision, and you of course have to have a quorum of the board, that has to happen at a public meeting. Mm-hmm. And so that's the difference. I come from a background of working at an administrative agency or an executive agency where we didn't operate under that. So it's different kind of a rulemaking process where, our board discussions about on the actions that we're going to take happen in a public setting.
Mm-hmm, mm-hmm. Does that mean that moving forward, even in terms of the timeline for the rulemaking and the informal rulemaking that is about to begin, that anytime that you have a draft rules, we'll see a copy of the draft rules even before they become proposed rules? Is that right?
We haven't discussed that, but I mean, if it has to be part of a board meeting, and materials are provided to the board, we'll follow the same procedure.
Mm-hmm, mm-hmm. Let's go to the next one. So 45-day hasn't begun yet, but can tell us a little bit about the timeline. So what do we mean when we say 45-day comment period? What is the rulemaking process? Is there a second round of comments that's possible? Just kind of walk us through what to expect.
Sure, I'll call this my OAL class for those that don't know. Okay. So if you think about us as an agency, the CPRA, the Civil Code section 1798.155 or 185 and 1798.199.40 requires the agency to assume responsibility for adopting regulations pursuant to the CPRA. So as required by the Administrative Procedures Act, which is in the government code, The agency is following the rulemaking procedures of the APA. The requirements are designed to provide public participation and actually to create a record for OAL review and potential judicial review. So last fall, the agency, pursuant to the APA, invited public participation in the process by inviting public comments on areas relevant to the regulations that we would be promulgating. The staff, working with the assistance from the Attorney General's office, then prepared the draft regulations and the draft initial statement of reasons. We always call it the eyesore. And that's what was published for the June 8th board meeting. So the next step is to submit that with a notice of proposed action, or the entire package we call a NOPA, to the Office of Administrative Law for publication in the California Notice Register. Typically, the deadline for doing something like that is you submit it to OAL on a Tuesday, and then it's published 10 days in the Notice Register, or 10 days later in the Notice Register, always on a Friday. And once that happens, that opens the public comment period. And at the same time, on that same day, the agency will then send to all of the people who have registered as interested parties for our rulemaking a copy of all that, or a link to it. And we'll put those documents on our webpage, so they'll be able for review. And that's when, and to be candid with you, we've submitted the NOPA to OAL this past Tuesday, which would mean we can anticipate that it would be published next Friday, and that would be the opening of the comment period. So after that initial 45-day comment period, we will have a public hearing, and the comment period is a minimum of 45 days. And so the notice that goes out will tell you when the comment period ends. And then the staff evaluates the comments that we have. There could be potential changes that are a result of those comments. If it's something that is a change sufficiently related to what was in the initial notice, it's reasonably foreseeable in the notice that change would occur, we would have to do another 15-day comment period. And in that 15-day comment period, the comments that we should be getting are only on the text that's changed. And so I always like to remind people, yes, you can comment on the change, but don't comment on what was initially noticed, because we don't have a responsibility to summarize and respond to that. So after we do all that, we have all of that material, we summarize it, we summarize the timely comments, what was at the public hearing, the 45-day notice period, any 15-day notice periods. We prepare our summary in response to them. The responses have to include an explanation of if we made a change and what that change would be, and if we didn't make a change, why we are rejecting the comment. All that is compiled into a document called the Final Statement of Reasons. It then gets resubmitted to OAL with the changed text of the regulation, the Final Statement of Reasons, and copies of everything that's in our public record. And so that entire file gets submitted to OAL for approval.
Thank you so much, Brian. So as what we are learning, I think, is that this is 101 California administrative law rulemaking process. And so I just want to highlight what Brian said and make sure that everyone heard it. So you heard it here. The notice to the OAL has been submitted last Tuesday. And so with the 10-day that it takes for them to post, I think what that means is that July 8th, next Friday, is when I think you said NOPA, the notice of proposed rulemaking will begin, and 45-day clock will begin next Friday. Is that right? Correct. Did I get that right? That's okay. Right. So now we have clear understanding of when the 45-day begins, and everyone hopefully will be taking a look at the draft regs, but I don't think there will be any substantive changes since this last time we saw the draft rules. So we really had all this time to be taking a look at the draft regs. We want to ask you a little bit about the history behind the preliminary informal rulemaking, because I think that also added to some confusion. And there was informal rulemaking that was not part of this official rulemaking. And there were a number of questions and there were a number of comments that were submitted. And Ashkan, maybe this is a question for you. Ashkan, have you been part of an agency like this before? What has it been like to be an executive director of a brand new agency, brand new privacy agency? I believe this is the first at the state level. And to be able to kind of shepherd this while you're just getting your feet wet as the new ED.
Indeed, thanks for having me as well. I've said this publicly a lot. It's probably the hardest thing I've ever done. but it's an incredible honor. I had the good fortune of having or work basically being able to rely on the substantive work the board did prior to my appointment in October. So just, you asked about the history. In September, prior to my appointment, the board put out a request for pre-rulemaking comments, to which we received something like 900 pages of comments on the substance of our rulemaking. Those materials range from input on our opt-out requirements, insurance regulations, and even automated decision-making. We also held a number of pre-rulemaking listening sessions in the form of informational sessions, instructive sessions for the board in March, where the board and staff heard from academics and experts on the topics relative to our rulemaking. And then finally, we recently held a series of 3-day stakeholder sessions to give members of the general public an opportunity to speak on topics relevant to the upcoming rulemaking. Those are all preliminary activities, and those are all available on our website. We're also redacting and making available some of the materials that the written materials that were submitted as part of those stakeholder sessions, and those will be up on our website soon.
All right. As you participated in the preliminary informal making, and we did hear during the last public meeting with the agency, it seemed like the California AG, I guess Deputy Attorney General Lisa Kim, I believe, was on loan, and she assisted, and the California Attorney General's office assisted in the rulemaking. What is the role of the executive director were you part of the drafting as well, or is it more administrative? Can you explain to us kind of your role?
So my role is kind of to oversee the operation of the agency, including the function of the subcommittees and the staff. Deputy Attorney General Lisa Kim and Stacey Schesser as well, to some degree, helped support the rulemaking as they're guided to in our statute. The CPRA guides the Attorney General to support an agency. And then we have a number of staff from either internally as well as from DOJ, including Brian, who have been actively working on the rulemaking with some input from the subcommittees. Yep.
Oh, perfect. Before I forget, I'm going to ask, there's a clarification question. The 45 days, is it 45 business days or is it 45 calendar days?
It can be confusing. It is 45 calendar days. And it's confusing because at the end, when OAL does its review of the package, it's 45 business days, or it's 30 business days, which basically maps out to 45 days as well. So the comment period is 45 calendar days. All right. Which I believe is August 23rd, if I'm not mistaken.
And so that goes to the next question. What is going to be in the notice? So we're going to see the notice next Friday. And I think that notice is going to spell out, is it going to have that date on there? Like, this is the date by which all the comments need to be submitted. Okay, great. So it'll be super clear next Friday.
Yeah, I can go over the main elements of the notice. The notice includes what is the close of the comment period. So it'll give you that date. It has instructions on how to comment, the time and place of the public hearing and how to participate in the public hearing, the name and telephone number of the agency representative to whom inquiries concerning the proposal can be directed. I think that's me. An informative digest that includes a summary of the existing laws and regulations directly related to the proposal, whether there's comparable federal law or regulation, the anticipated benefits of the regulation, estimates on economic impacts, including cost savings, mandates on local agencies, the identification of the types of businesses impacted, including whether there's statewide adverse impacts on businesses' ability to compete with other businesses, and impacts on housing costs. And lastly, an explanation of how to attain a copy of the final statement of reasons once completed and how material published on the website can be accessed. So all of that's going to be included in that notice.
Right. And I think we just addressed the second question already. How will we know? Brian, you were saying that there is a web page. If you go to the agency webpage, you can sign up to get notices like this, right?
Right. The easiest way to get on our mailing list is to go to our website, www.cppa.ca.gov/regulations, the whole word, and scroll down to the heading that says notifications regarding this rulemaking process. You select, please subscribe to our email list, and you provide your contact information. You can request to receive notifications via email. which gives you the opportunity for same day delivery of everything that we put out. So I would highly suggest that if you want to get on the mailing list to be able to see everything as it comes live, go to the website and sign up.
Fantastic. And Ashkan, as you said, there were a number of kind of stakeholders meetings and several presentations that were done as part of preliminary informal rulemaking. Could you tell us in the notice, I believe when we were preparing earlier, I believe there are some additional hearings that you are planning during the 45-day. Could you speak to that?
It will be in the notice, and it will be shortly thereafter the 45-day period. We'll be holding hearings as required by the APA rulemaking process. We plan to do those similarly hybrid. We found that we had something like 400 people at some point online and maybe two or three in person. So we find that the hybrid approach actually allows for kind of diverse stakeholders from across the state. If you recall one of our earlier board meetings, a number of commenters remarked that it's much easier to join a Zoom meeting than it is to drive up to SAC, and we think that's really important to allow diverse kind of voices to be heard, not just people that live in SAC.
Mm-hmm, mm-hmm. Did I hear you say after? So are the hearings going to have the public hearings where you hear the comments from the public? Is that during the 45-day or after the 45 days has passed?
So Brian can speak on this. I think they can occur either. We are going to do them after. So we're going to do them on the 24th and 25th.
Right. And with that, officially the comment period will close at the close of our public hearing. So if we go over to the 25th, we will be accepting comments until the close of that proceeding on the 25th.
Of August 25th.
Right. Correct.
Oh, I see. Okay, so you'll actually keep the comment period open until the hearings have closed.
Right, because one thing to remember, the 45 days is a minimum. We have to, at a minimum, have a 45-day comment period. Typically, agencies hold the public hearing a short period of time after what has been identified as the 45th day.
I see.
So for us, the 45th day is going to be August 23rd, and then the 24th and the 25th, we have, as specified in the notice, we will have the public hearing. And that can be, you'll see that you can participate either by coming physically to it or by webinar or through the web contact. We're encouraging people to participate by the web contact just for safety reasons.
Mm-hmm, mm-hmm. That makes a lot of sense. Okay, so that's really helpful because I thought the 45-day was a fixed period. So it's a minimum of 45 days. But we should expect public hearings to take place at the end of that period. And so really the full comment period is likely going to be that 25th. I'm looking at my calendar. That's a Thursday. So that would close. And all of this will be explained in the notice that we see next Friday, right? With all the dates. Okay, so we don't have to count. We don't have to try to figure it out. But for those of us that are listening in, I think we can generally expect this to be in the notice that we will see on July 8th, because we're all going to sign up for the mailing list that Brian told us about. All right, let's go to the next slide. Rulemaking goals. When I was talking with Chairperson Jennifer Urban, she was originally going to be on this panel, but she was unable to participate. And so we're very lucky to have Ashkan join us. When we were talking to her, she had explained to me when we were preparing for this was very helpful. So if you can tell us, Ashkan, there are 3 components, she explained, to the rulemaking goals. And this was talked about during the last public meeting. What do you mean when you say that there are 3 kind of rulemaking goals, 3 components, I think is the word that you used, to the rulemaking that we are about to see in this notice?
Yeah, and indeed, Chairperson Urban and Board Member Sierra also discussed this in some detail during their presentation in one of the recent meetings. The first is to update the existing CCPA regs and harmonize them with the CPRA amendments, essentially to address confusion and clarify what is meant by the regs. And some of that is, for example, adding the right to correct or the right to limit, where it is required in the CPRA, it doesn't exist in the existing CCPA regulations. And so therefore, we would update the CCPA regulations to incorporate some of the statutorily required provisions in the CPRA. The second is to operationalize new rights. For example, there was a bit of confusion in response to our rulemaking with regards to our probable cause proceedings, which just simply repeat the statute. Folks misunderstood that this might be our entire enforcement process, but it in fact only reflects the initial stage. The statute guides us to, or directs us to, hold probable cause proceedings in advance of taking an enforcement action. And after the determination is made, the state requires administrative hearing to be conducted in accordance with the hearing procedures of the APA. So that's a lot of what the operationalizing CPRA amendments do, is to add these new provisions. And then lastly, and I think a really important piece, is we effectively reorganize and consolidate certain aspects of the law to make it more accessible and digestible. This is, for example, moving topics relevant to the notice requirements, required disclosures and communications to the consumer, all into one section for clarity. Otherwise, they're interspersed between some definitions, some new rights, and some of the existing regulations. And so this is a great deal of undertaking. Functionally, it doesn't necessarily substantively change the law, or the regulations, but it importantly clarifies it so that you can see all the rights, for notice, all the rights to opt out, all the rights, in certain sections. So those are kind of the three main goals, and I think we did a pretty good job at achieving those in this most recent package.
I think that's really helpful, and specifically on that third point. You mentioned the opt-out right. The service provider sections also, I believe, from different places within the statute and the regs. I think what we see here is that it's what is in the statute has almost been restated in the regs too, right? So instead of having to take a look at the statute and the regs separately, hopefully, I think this is really the work that was significant work that was done by the drafters, is to put everything in the draft regs. So it kind of combines the two into one source. Is that right, Ashkan?
That's right. That's right. And really, so the bulk of what's new isn't necessarily a reiteration of the statute. That isn't necessarily, for example, having a fiscal impact. The fiscal impact comes from the statute, but it's included in the regs just to, for example, clarify or outline readability or help people see everything in one place. I recall being involved in CCPA and folks in the legal community complaining that there's requirements and definitions and things all over the place. So hopefully these regs kind of help to consolidate and operationalize some of the requirements of the law more easily for folks.
Yeah. Having said that, I think Chairperson Urban wanted me to say, it doesn't mean that you got everything, right? It doesn't mean that it is, if it's not in this one section for service provider, it's not, it doesn't matter. I think what we want to really stress and emphasize, for everyone paying attention is to read the statute, read the regs, and also read the ISOR and I guess the FSOR, the final statement of reasons. So I think we want to talk about the sources of materials. If you can kind of explain to us, that each material that become public really has meaning, right? Even the notice of rulemaking that we are expecting to see, there's going to be some good guidance and information there. And then there's a statute, of course, as amended. And I think I like to say, as part of the bar, the privacy bar in California, we found that that practitioners, even just keeping track of what statute to refer to, all the citation numbers have been changed and they've been amended several times. So knowing what statute is now the law, it has been kind of hard to keep track of. Plus the draft regs, you need to keep track of all the draft regs and the rulemaking that happened under CCPA and now under CPRA. And then now we got the ISOR, which will become the FSOR. Can you tell us a little bit about all the different sources of materials and what each does that's maybe different from each other?
Yeah, so I'll let Brian answer the kind of documents relied on question. If you want to jump into that, I'll just flag that someone asked for a repeat of the instructions on getting notifications. If they could, I can answer it in the chat or paste it if that's helpful here. So I'll do that to all the to everyone. This is the URL for signing up for our mailing list. And please subscribe to essentially receive notifications on either board proceedings or, in this case, rulemaking, and they'll be notified when the NOPA goes out, for example. Brian, do you want to take the question around documents?
Yeah, I mean, the way I look at it, of course, the initial source material, of course, is the statute. And when we look at it, you had the CPPA and then you had the CPRA. And so what these regulations, the source material for these regulations are the CPRA, which is the Prop 24 from the 2020 election cycle. And from that, and it's the interesting thing, when you read the regulations, you'll see things that are underlined and you'll see text and strikeout and you'll see things in different colors. And that's just to make clear what is being taken away and what's being added. And so so text that was in the prior regulations that is being deleted will be in a strikeout format. And then text that's being added will be in an underlined format. The way I like to think of it is if I'm reading this to be able to provide comments, really a good map to what is in the regulations is the initial statement of reasons. Because in that document, it not only provides kind of a summary of what the specific sections say, but it also explains the necessity for it, which is one of the elements that the Office of Administrative Law uses to determine whether or not the regulation should be approved. And so I often suggest to people, it's like, look, before you even read the text, read the initial statement of reasons, because it's a good primer to actually start reading the text of the regulations. And so your best source material on it is actually that ISOR document. I know it's voluminous because, when I was looking in my binder, I think the text that we have is about 60 pages long, and the ISOR itself is probably 60 to 70 pages long. So it's a lot of material, but it's going to be easier to digest if you really dive into the initial statement of reasons first.
I found it really helpful. So thank you for emphasizing how important it is for those of us that are trying to understand kind of the intent, right? Intent of the agency, intent of where the draft regulations, the goals of the regulations. And the ISORs, I noticed that there are several places where you talk about the marketplace. You actually comment about confusion in the marketplace and how the agency is really kind of trying to provide guidance on what we meant, what you interpret the law to say. So can you maybe tell us a little bit about that process? How do you go about, I think you mentioned, hundreds of participants in the rulemaking process and the comments that were submitted in the preliminary comment period and also during these stakeholders meetings. How does, given that you have the Open Meetings Act and you have to do everything in open meetings, are there meetings happening between the board, I guess the members of the board? Are there subcommittees that are meeting separately? How do you put all of those hundreds of pages of comments together and come up with where we are, the draft regs and the ISOR?
It's interesting because, with the Opening Meeting Act, you can have subcommittees of the board as long as it's composed of less than a majority of the board. And since our board's only 5, our subcommittees can only consist of two people. It's a lot of material to go over. And I think that's the important part of this process was the preliminary actions that we took. Mm-hmm. Getting the 900 pages of comments. Of course, we had to review all of that, summarize it, and see where people had concerns, and then basically educate ourselves. And that was the 2 different sessions that we had earlier this spring. First, where we had experts come in and provide us advice on specific topic areas. And then we had to open it up with respect to the topic areas to receive comments from the public with respect to it. All of that was put into consideration in drafting it. And then also we used, like you'll see, as part of our initial statement of reasons, sources that we relied on, just papers and things that had been written. So a lot of this material was considered by us, discussed with the various different subcommittees, and that went into the drafting of the text of the regulation. Mm. So it's a lot of work. I came on board in October, and I'm surprised that we got as much done in what I would consider to be a short period of time.
Right. Absolutely. So are there subcommittee meetings happening between the public meetings?
On a regular basis, yes. I mean, because that's how we have to, break down the task. How do you go about like actually getting a rulemaking off the ground?
Right.
What is the new stuff that we need to add? How do we change the existing stuff? And so we have to, in order to be able for the board to be able to interact with staff and on an ongoing basis, as opposed to just, the once a month having a scheduled meeting, we actively participate in subcommittee actions.
Mm-hmm. Okay. So here is, I have to emphasize, there's my list. This is what I had sent earlier to Chairperson Urban. And I said, hey, Jennifer, here are all the things that I see that are just jumping out at me. So again, this is not prepared by the agency, it's prepared by me. And if you take a look at, I try to do the cross section. I try to put the section numbers of what is in the draft regs and sometimes the eyesore. There's a lot. I mean, there are some meaty topics from new consumer rights to, explicit consent. What does it mean to get explicit consent? A lot of new regulations, proposed language on the opt-out requirements, GPC, the opt-out preference signal. There is language about verification relating to opt-out, and specifically about how to effectuate an opt-out and how to engage with third parties and service providers. There is what I think is quite subtle, but very material change in the notice of financial incentive. I know because it really clarifies the discriminatory practices and when the notice of financial incentive needs to be provided. And then there is a lot of new guidance on service providers and third parties and the contracts related to them. So here is my kind of summary of the things that were jumping out at me and places where we might ask for some comments. There were some question from the audience. What is the most effective way for the privacy community to provide comments? If you have questions, if you are looking for clarification in any of these or more, this is obviously not an exhaustive list. What is the best way to engage? Is that through the formal rulemaking that is, I guess, about to kick off on July 8th? Is that the most effective way, is to submit written comments and or participate in the public hearings that will happen on the 24th and the 25th?
That's exactly the best way to do it. And it's interesting because we have some tips that were on the Attorney General's website on how to participate. And I think, Ashkan, if you can provide the link for that. The public is free to submit comments. And that's the whole point of the APA, is that it's a public participation in a rulemaking process. And so what encourage people to do is, if you want to, one, as I mentioned earlier, sign up to get on our mailing list, or else you'll have to, go to our website to see all the documents. If you're on our mailing list, we'll send you an email with everything attached. And then kind of like tips on how to participate is it, as I suggested, read the eyesore first, and then go into the text and then see where you have specific questions, concerns, criticisms, constructive suggestions, and then you would put those in your comments. What makes it really easy for us, the staff, and I'm going to plug, making this an easy task for the staff, because we do anticipate we're going to get a lot of comments, is, as you submit your comments, it's in the sections are sequentially numbered. If you have a question or a suggestion with respect to a specific section, give us the section number so we can know where we need to focus our attention. So, I mean, that's the biggest tip. Read the eyesore, go through the text, and then provide your comments based on the section numbers that are in there. And of course, I've worked on many major regulation packages, and everywhere, no matter how many people have looked at it, you're going to find the typos, and we're not embarrassed for you to tell us where we've made a typo.
Indeed, and I'll just add, the public is free to submit comments in written form or digitally. As a technologist, I'll note that digital comments are somewhat easier to process for us. For example, adding your comments as an attachment to the email rather than the body, and making sure the attachments don't include any information you don't want public, since the comments will be made available to the public. So making sure that the attachments don't include your personal email, office phone number, et cetera, does make the processing easier since they'll be posted online. And Brian, as Brian mentioned, also ordering them and making them kind of digitally accessible also makes us easier to process.
That's a really good practical comment. As we're preparing for this webinar, I think we were talking about how sometimes the comments that you receive at the CPPA, maybe they're not addressed to you. Maybe it's just an advocacy comment to the world, about what is the meaning of privacy and how, we see, certain of these privacy practices to be in the marketplace. But what you care about is what the agency can do, right? And what you can do as part of the rulemaking is limited. So can you tell us what is not effective? What kind of comments can you really do nothing with? For example, I think one of the examples that Chairperson Urban said before is you can't change the statute, right? So if you have some concerns, some criticism about the statute, this is not the forum because you really can't do anything about it. What is not helpful in terms of receiving comments for you?
Exactly that. I was going to say exactly that. I mean, I've been through major rulemaking projects for almost 30 years. And always there are the comments that are complaints about the statute that we're working from. And what people should realize, of course, under our system of hierarchy of laws, a statute is supreme over a regulation. And so a regulation can't necessarily conflict with the statute. But what that also means is that a regulation can't narrow the scope of the statute or expand it. And so the comments that are criticisms of the statute, really we have to summarize it. But of course, that's not going to change the regulation. And so what you would see is that we would summarize that comment and say the agency rejects it because we can't change the statute through the regulation. And so like one of the tips is, we understand that there will be comments that are meant for a broader audience. But it's just that the agency can't take any action to make a change that is basically a change to the statute. So that's the one big thing that I find to basically advise people. If you make that comment, your disappointment may be when you see the final statement of reasons, we've rejected it. And that rejection is only on the basis of, yes, we understand what you're saying, but we can't change the statute.
What you're saying, though, is that every single comment you receive, you have to respond to, and the public will get to see how you listened to the comment and how you responded to it. Is that right?
That's correct. I mean, part of the process is we have to, not only the comments that come in the written form, but we have to summarize the comments that are part of the public hearing process. And in addition to that, the public hearing will be transcribed. And so part of our final record is the transcription of that. And so our summary of the responses and of the comments and our responses to them are all part of the final statement of reasons, which means that's, if you think the ISOR is a large document at 70 or so pages, just imagine how big the final statement of reasons will be. But we have to respond to every single comment that we get during the public comment period.
I think that's really important. Again, I say this from a practitioner that's living and breathing this. That's what we did during the CCPA rulemaking, right? So this sounds like it's similar. So for those of us that participate in the CCPA rulemaking, it's going to be similar with the CPRA rulemaking. And what we saw during the CCPA rulemaking is, here's my practitioner's tip. I would literally just do a find search. I would do a find opt-out, find service provider. And I basically had, every single time opt-out was mentioned in the comments and the responses. And I read through all of it. So I knew exactly what the AG said, because AG was at that time the enforcement authority about the subject of opt-out, service provider, et cetera. So I think that's what we would expect here too, is that we will hear from you on the CPPA, what you say, let's say, about GPC, what do you say about, notice of financial incentive, et cetera, if we do a search on the statute, on the regs, and the ISOR, all the different sources of materials. So I found that to be helpful. Again, if you're trying to make sure that you don't lose, some part of it, because it doesn't have to happen to be kind of neatly placed in one area, I just do a find search and find every single time a certain word is mentioned. That has been something that I've used, just kind of a simple manual way of making sure that we haven't lost a piece of it, the puzzle. So let's talk a little bit about, I'm getting a lot of questions as we expected about enforcement. So seeing as how there's a lot here, I mean, this is just, things that just jumped out at me. There's less than 20 here. There's a lot more, obviously. Question about enforcement. when will enforcement of the law begin? The law becomes operative on January 1, 2023. 6 months after, I think it's the calendar that we're looking at once once the regs are finalized. Is there any discussion about pushing the enforcement date?
So the agency hasn't said anything about the enforcement timeline, but as you recall in past meetings, this is something we've heard about, and board members have individually remarked that they're aware of the issue.
Okay, so nothing more yet is, I think, what I'm hearing. Again, the statute doesn't change, right? The agency has no power over changing how the statute is written, all about the enforcement authorities. And so I think we have to assume that the law is the law. Could you tell us a little bit about kind of the shared enforcement authority between the AG and the agency, and maybe even talk about as part of rulemaking, do you expect, can we expect that the California AG office will continue to participate in the rulemaking moving forward? Will there be enforcement sharing as well in terms of sharing target companies?
That's a great question. That's also not something we've really discussed in detail. The statute guides us to have administrative enforcement, and the Attorney General has civil enforcement over the law. They also guide the AG to provide us assistance until which point we don't need their assistance any further. So it's not something we've really publicly discussed, but the statute's pretty clear on both those matters.
Right.
Something to add.
Yeah,
I was going to say, I think something to add is a comment that Ashkan's made many times. It's like building a car or driving a car while you're still building it. And so he had the enviable task of coming on as the executive director of an agency that just had a board when he came in. And so yeah, we've used a lot of the assistance that we continue to receive from the Attorney General's office based on what's required by the statute. But at the same time, this guy is running around not only getting this regulation off the ground, but actually building an agency around him, including, in the future, that enforcement staff that we're going to have. So I'm just impressed with the amount of work that he's able to get done.
Right.
Thanks, Brian. That's very kind.
Yeah, no, they're absolutely. And we know, I think we're going to mention at the end of the call, the number of openings that you have for those of us that are looking to join the wonderful office for the staff to be part of the agency. And I put a little plug in there. There is a section that talks about an audit that's going to be done by the agency. There is a requirement for risk assessments and cybersecurity audit that is going to be done at the regs level. I think you alluded to this. Maybe we can kind of jump back into it. There are a number of topics. I think you mentioned automated decision making as well. There are a number of topics that are not part of this package, right? This initial rulemaking package. Can you talk a little bit about, will there be a second rulemaking that happens before the end of the year that would address that latter part of the topics that were not in the initial rulemaking?
That's a great question. Again, it's not something the board has really come to agreement on or discussed. We know that as part of this package, these were the priorities for the agency and for the board, and so that's what we included. There is a subcommittee concerned with some of those new topics, and I expect they'll be actively discussing those in future meetings, and we'll see where they land. Okay.
Meaning that could happen in parallel, right? And while this rulemaking happens, if the other subcommittee members put together, a set of draft rules, that they could move forward too.
That is correct. Brian, please correct me if I'm
no, that is correct. Yeah. Okay. Yeah. I mean, there could be a second proceeding that would go, but just based on the timing, they wouldn't land at the same time as final approved, just a fluke of the timing. Yeah.
Right. And I think so far, just to summarize, because I've been listening in to the agency meetings, I think there's been no timeline given on the second set, the topics that were not in this initial draft. For those of us that looked at the list of topics that were in the informal rulemaking in December, a number of those topics are not addressed in this rulemaking that probably will be addressed. We don't have a timeline on those. Okay. And I think what we heard during the last public meeting, Ashkan, if you can just say it again, in terms of timeline for this rulemaking, it sounded like the agency was targeting to have this rulemaking wrapped up by the end of the year. Is that still, I think November, I think it's kind of a month that we had heard. Is that still the case?
We're at the behest of the APA. I'll let Brian kind of talk, but we essentially, as he laid out in the initial presentation on rulemaking process, there's a number of steps, each associated with time, including additional revisions. And depending on what that process takes, will ultimately dictate our timeline.
Mm-hmm.
Yeah, you have to think that one, the APA, you have a year from the time that you notice your regulations to get it to OAL for approval. And so really when the notice goes out next Friday, we have a year from next Friday to get it submitted to OAL for approval. It's not going to take us a year, but one thing to think about it is that the APA builds in basically 90 days that's out of the agency's hand, which is the 45-day comment period at the beginning, and then the OAL review period at the end, which is a 30 business day time period. So that really maps out to another 45 days. And so you also have to build in the time that we as the staff is going to have to do once we receive all of these comments. And if we gauge by what was happening in our informal process where we received 900 pages, you can imagine that we'll probably receive something equal in the comments on the reg text that we do. So we have to calendar in time to be able to do that. If we have to make some substantive changes that require a notice, that'll be a 15-day notice. So you have to build in the 15-day notice time for that.
That's the second rule. Okay.
Yeah.
If you do a second round, that's
exactly.
only going to be 15 days, not 45 days.
Yes.
Mm-hmm.
And then there's time to review what comes in from that, and then formalize all of that, get it into a final statement of reasons, and then get it to OAL. So you have to imagine that even outside of these public processes, there's time for us to do staff work that you have to kind of calendar in. So will it land at the end of the year? It just depends on how voluminous the comments that we are. I couldn't say that it would be November because those days just don't map out. But we can anticipate that it'll take us several months to finish the process, and then hopefully quickly get at the end of that the end of OAL's 45 days and approval of the regulation. So
45 days cannot be expedited, as far as you know. So 45 days
for OAL. No, OAL's review is by statute. It's 30 days, and then under an OAL regulation, they've clarified that it's 30 business days.
Oh, I see. 30 business days, which turns out to be more calendar days. Got it. So 30 business days. Definitely. So at the end of everything agency has done, there will still be another 30 days for the OAL to approve, which sounds like was a similar process with the California AG as well. And I think, if I recall, OAL actually had some changes that they wanted the AG to make, and that was reflected in the final draft regs.
Of course, that's always part of the process. I've worked on many major regulations, and on that 29th day, you get a call late in the afternoon with OAL saying, we have some suggestions, and so you just have to scramble and address them.
Mm-hmm, mm-hmm. Yeah, I thought that was really interesting because I didn't take into account, the OAL's role in this. So I'm just looking at the questions here. There was a question about the subcommittees. I believe the list of subcommittees for the agency is on your website, the CPPA website.
That's right. You can refer to the September meeting slides where the kind of rulemaking subcommittee at that time presented the list of the different subcommittees that we have, and we have different topic-specific subcommittees that we've created. Mm-hmm. So look at the September slides. Yep.
And I'm getting a couple of questions regarding the employee and the B2B exemptions. As you probably are aware, we're all watching to see if Sacramento is going to have an amendment that's going to either extend the exemption or do something else about employee privacy rights. Is the agency engaged in any conversations? I don't think you do, get engaged in like a legislative, you don't have like a legislative affairs group within the agency. Can you explain to us your relationship with Sacramento in terms of lawmaking?
It's a great question. We do indeed have a legislative affairs
as directed.
And we announced, it was Maureen Mahoney from Consumer Reports. We're very excited to have her. She has over 10 years of experience in this area. But we have not been engaged on this question of the B2B employee exemption.
So please educate me, because I didn't realize that. Meaning you do have a legislative affairs, and sounds like a person that is very capable. So you could be lobbying. Would the agency be able to lobby for certain changes in the law?
We're not taking, presumably the board would want to have input on what changes in the law that we would request, but we have not been engaged, for example, on this B2B provision. That's kind of on many levels above my pay grade. So we essentially are focused on implementing our statute and then are waiting what the legislature decides on how to address some of these key provisions.
I see. But the fact that you have a legislative affairs office, that means that you could. I didn't know that the agency could engage with the legislature in terms of giving your input in terms of what kind of laws you might want to see.
Or we provide technical assistance. As you might know, there's about 13, last count, like 11 or 13 bills in the legislature that would change or even expand our agency's authority. And so we provide technical assistance to the degree we can on help clarifying how those would impact the agency. And then the board would ultimately take a position on legislation should we have a position. Thus far, we haven't. As you know, we're very early in the process for a lot of this.
I'm thinking, we know that you have your hands full with the CPRA, but is that possible that the CPPA would have a broader jurisdiction? Would you be enforcing or maybe putting together rules for other privacy laws that come out of California?
That's a great question. Again, outside of kind of our pay grade or my pay grade, that's something for for Sacramento just to decide. I'll flag that we are not the only consumer protection agency in California, right? California has a history of, we have a sister agency, DFPI, the Financial Protection Innovation, Department of Fair Employment and Housing, Department of Justice, civil rights groups. There's similarly HHS, Health and Human Services, a number of agencies there. So we have a number of agencies here in California, and most likely the legislature would grant each agency whatever powers are appropriate. We are the privacy protection agency, as you know, so that's pretty much our focus at this point.
Right. But for now, just so that we all know, your jurisdiction for now in terms of the law is CPRA and CPRA only.
CCPA, right? So the CPRA amends
CCPA amended by CPRA.
That's right. It creates not only amends the CCPA, but essentially creates our agency and grants us administrative enforcement over the act, which is the CCPA.
Could you explain this? Because a client actually asked me that, and I want to make sure that I'm using your words. What do you mean when you say civil authority versus administrative authority to enforce?
Ryan, do you want to take that?
Yeah, if you think about the civil authority, that's the AG, who is the chief and law enforcement officer of the state. As in the statute, if there is a civil proceeding, a court proceeding that's brought for enforcement under the act, that would be handled by the AG. When we speak of administrative enforcement, the statute also gives the agency to hold what would be more of an administrative hearing. And under the APA, that's a hearing before an administrative law judge who, you same kind of a case, you present your evidence, and then you get a proposed decision, which would under the CPRA have to be approved by the board. And so it's two different kinds of proceedings. One is what you're used to as the traditional court proceeding. And then the other is, like with a lot of other state administrative agencies, it's an administrative proceeding that's held before an administrative law judge, and the penalties there are set forth in the statute.
I see. I do want to just pull on that a little bit, though, Brian, because it doesn't mean that the California AG enforcement was only in the courts, right? Because I know that we worked with several companies in responding to investigations that none of them went to court. So the civil authority about the California AG, I think, is similar in a sense that they could have investigations, none of them see the light of court. But I guess that is the end result. If it were to move forward, it would end up being filed in California courts. Whereas for the end result of an enforcement proceeding by the agency would be before an administrative judge. Is that right?
That's correct. I mean, there's always a possibility that, just like in a court proceeding, a matter could settle, a matter could be cured.
That's right.
And so you may see things that you think that are going to, you'll see in court may not, because it gets resolved. Or even after the filing of something in court, it may not get to a trial or a hearing because it got resolved. And the same is true in an administrative proceeding.
So we could see enforcement actions by the agency that could settle, again, that never goes to the administrative law judge. In the case of the CCPA enforcement by the California AG, what I understand is that if there is a settlement, it becomes public. There are no confidential settlements with the California AG. Do you know the answer for the CPPA? Would enforcement actions by the agency become public as well if there's a settlement?
Yeah, that's a great question that I had not thought about before. So you got me pinned down.
I threw you a coverall. That I know that was not a question that we had previewed. So
yeah, so I'm going to beg off on that one.
That's perfectly fine. And I think we are getting requests for this group to maybe come back and do another webinar. So maybe we can talk about a little bit more about the enforcement at a later date. I did get a question from Sherry here about the ALJ, the administrative law judges. Will they be hired to adjudicate the CPPA actions, or are they more generalists? This is a question that we did not prepare for. I don't know if you have an answer for that.
No, because they are a part of the Office of Administrative Hearings. So you have OAL and OAH. And OAH has the administrative law judges throughout the state. I can't say whether they're specifically specialists because they hold, they preside over hearings for all of the state regulatorily licensed bodies. And so you might have an ALJ who hears a real estate licensee case one day and a car salesperson case the next day and a board of medical quality control case the next day. I mean, they're generalists. And then sometimes they may get set to specialize in specific types of matters for different state agencies.
Okay. I am getting a number of substantive questions, and I know fully well that this slide that I have up is probably going to lead to even more questions. So I just want to let everyone know that the California Lawyers Association, we represent the California privacy lawyers, or those of us that are practicing law, and we represent, this is the Bar Association for talking about California privacy law specifically and privacy law generally. We do have several webinars that are focused on the CCPA and the CPRA, obviously, and we will continue to have the good fortune of having the relationship with the CPPA, and we'll be inviting hopefully you back for another webinar. So please stay engaged with us, sign up for our mailing list, sign up, join the Bar Association. I think, John, if you can put the CLA privacy law section website onto the chat, please, so that anyone that is interested in any of our future events, you can please sign up. There were a number of questions that are coming through from the audience that I think we addressed. So I'm going to try to kind of summarize what we learned today in the next 2 minutes. And then Brian and Ashkan, please let me know if I have misstated any of them. So there were a number of questions that we that addressed about the timeline. So the 45-day clock has not begun. It will begin next Friday, July 8th. On July 8th, we will see a notice of proposed rulemaking. If you want to see a copy of that and be the first to know, you should sign up on the CPPA website. And I think the webpage for signing up for those rulemaking processes were provided in the chat. Sign up for those rulemaking changes. After the 45-day has run through, the agency is also planning to have 2 public hearings on August 24 and 25. That rulemaking and comment period is the most effective way for the privacy community to engage with the agency if you have any questions for clarification or if you have any concerns. The most effective comments that the agency can get are real examples. So if you think a certain rule is going to be burdensome or too hard or or unclear, please give examples, give red lines, and don't just say this sucks. Say this is how we would like it to be. A red line is more effective. A proposed new language is more effective than just saying this is not good. So we really encourage everyone to participate in the rulemaking. After that, there was a question about it. Will there be a second round? Unclear. It depends on how many comments are received. If the agency decides to make any substantive changes to the draft regs, there will be a second round. It'll be a 15-day instead of a 45-day. And we did clarify that in the notice, it'll say exactly when that date is. So again, you'll know when that 15-day is up in the second round. We talked about the number of topics that are not addressed in this initial rulemaking, and they will they will be addressed at a timeline unknown at this point. We don't know yet if they will be addressed this year or maybe next year. I think we can expect that the agency will continue to participate in rulemaking even after the January 1, 2023 deadline. No comment yet on the employee exemption. There is no discussion specifically to legislate on the employee exemption extension or not, although Ashkan was good to tell us that they did hire a legislative affairs person. And so we could expect that some legislative comment and the feedback and technical assistance will be provided by the agency, although we don't know yet if that's going to include any specific discussion about the extension. I think that is the major things that we have learned in terms of timeline and the rulemaking moving forward. Please sign up with the CLA privacy law section mailing list for additional webinars that are going to be focused on these specific topics. In fact, we have subcommittees for the CPRA rulemaking, and the California Lawyers Association will be participating in the rulemaking and providing comments on behalf of the Bar Association. So Brian and Ashkan, thank you very much for your time. And hopefully you'll be hearing from our privacy law community in California with our consolidated comments. And we really look forward to hosting you again. Thank you very much for your time.
Thank you.
Very nice.
Bye-bye.
Definitely.
Bye-bye.